Hello, and welcome to the San Diego SHRM Quarterly Employment Law Update. This is your Quarter 3 update for 2016. I am Christine Mueller, the Vice President of Legislation for San Diego SHRM. Today, I am pleased to highlight for you the new Department of Labor overtime regulations, updated posting requirements, the new San Diego minimum wage and sick leave ordinance, new and pending state laws, and some recent case developments. We will first discuss developments at the federal level and then move on to the state and local levels. So let's get started with the new federal overtime regulations. In May of this year, the U.S. Department of Labor issued its long-awaited rule that defines exemptions from overtime requirements. These changes become effective on December 1, 2016. The new rule primarily addresses the minimum salary levels needed to classify executive, administrative, and professional workers as exempt. In order for an employee to be classified as exempt under the Fair Labor Standards Act, he or she will need to earn a minimum annual salary of $47,476, which is more than double the current amount. In addition to the salary level, exempt employees must also meet certain duties, which are not changed by the new rule. California employers need to take note because the new federal salary threshold is higher than the current salary threshold under California law. It is prudent for California employers to examine both the minimum salary test and the minimum duties test for exempt employees under both California law and the FLSA, to ensure that exempt employees are properly classified under both laws. Next, a quick note on federal posting requirements. Effective August 1, the Department of Labor issued new posters related to the Fair Labor Standards Act and the Employee Polygraph Protection Act. Revised posters may be printed from the Department of Labor's website. These are two of many required notices that employers must post in a prominent and conspicuous place in each establishment. So this is a good opportunity to make sure that your other postings are current. By now, employers in San Diego have heard a lot about the new Earned Sick Leave and Minimum Wage Ordinance. This ordinance, which was approved by San Diego voters this year, became effective July 11th. There is also an implementing ordinance, which is effective September 2nd, which amends the original law, providing more flexibility to employers. The local ordinance applies to any employee who works at least 2 hours within the geographic boundaries of the city of San Diego. Minimum wage in San Diego is now $10.50 per hour and will increase to $11.50 per hour effective January 1, 2017. With respect to sick leave, employers must provide at least 40 hours of paid sick leave per year. This local law differs from the state paid sick leave law in many respects. For example, no employers are exempted from the local law, and all employers must provide paid leave that can be used as sick leave. The reasons that employees may use San Diego sick leave are also expanded and include business and school closures for public health emergencies. San Diego employers may use the accrual method or the upfront method of providing sick leave. Employers may also provide other forms of paid time off that can be used as sick leave in order to satisfy the requirements of the ordinance. Sample notices and other information can be found at www.sandiego.gov on the City Treasurer's page. And you can also refer to prior editions of the monthly resource published by San Diego SHRM for details on the new ordinance. Now let's discuss some new California state laws. First, at the statewide level, the Private Attorneys General Act, or PAGA, was amended with some procedural changes. the PAGA allows private citizens to step into the shoes of the Labor Commissioner and seek penalties for labor code violations. These procedural changes include filing fees, online filing requirements, and the requirement that settlements of PAGA claims receive court approval. Second, through AB 2535, Labor Code Section 226 has also been amended to state that employers have no duty to track hours worked on itemized wage statements for employees who are classified as exempt. Remember that salaried exempt employees are paid the same amount each pay period, regardless of the number of hours they work. And third, through AB 1684, the Department of Fair Employment and Housing is now authorized to investigate and prosecute human trafficking complaints, similar to how it investigates claims of discrimination on behalf of employees. Let's switch gears from our discussion of new laws and talk about some recent cases that impact California employers. First, the U.S. Supreme Court clarified the timing requirements in filing a constructive discharge claim. A constructive discharge claim typically arises when the employee alleges that his or her workplace is so intolerable that the employee is forced to resign. According to Green versus Brennan, the time that an employee has to file such a claim begins to run at the time the employee resigns. This is an important clarification because sometimes an employee will resign but make the resignation effective at a later date. Under this case, the clock starts running on the day that the employee provides notice, not the last day of employment. If the employee waits too long, the claim may be time barred. In our next case, coming out of the Ninth Circuit Court of Appeals, Corbin versus Time Warner Entertainment, an employer was permitted to round employee time entries. With Time Warner's system, employees had to log in before beginning work, and the timekeeping system rounded each timestamp to the nearest quarter hour. For example, an employee who clocked in at 8:07 a.m. would see his time record reflect a clock-in time of 8 o'clock a.m. And an employee who clocked out at 5:05 p.m. would see his time record reflect a clock-out time of 5 o'clock p.m. Applying federal regulations, the court determined that Time Warner's rounding policy was proper because it was applied neutrally regardless of whether the employer or the employee was benefiting. Although this is a favorable decision for employers, it should not be interpreted as a blanket approval of rounding practices. The California Supreme Court has not yet weighed in on the applicability of the federal regulations on rounding to California state wage laws. California employers who adopt rounding practices should ensure that such practices are neutrally applied so that they do not result in failure to compensate employees for all time actually worked. Continuing with wage and hour cases, a California appellate court recently discussed the standard for combining rest breaks. In Rodriguez versus E.M.E. Incorporated, the employer combined the employee's 2 10-minute rest breaks into one 20-minute rest break. This was because of the nature of the employer's business. Employees were responsible for painting metal parts, and it took a lot of time to stop the processing lines and have employees take off their gear in order to prepare for a rest break. There was also evidence that a combined 20-minute rest break was preferred by the employees. So the court outlined the standard for combining rest breaks. Normally, separate 10-minute breaks are required, but in some circumstances, breaks may be combined if there is no effect on employee welfare and if it is done to ease a burden on the employer. This case is a reminder that California's rest break rules are very technical and often require a fact-intensive analysis. Deviation from the rules is likely to result in a class claim. Employers can be proactive by distributing and enforcing rest break policies and training supervisors on how to implement those policies. The last case that we will discuss today addresses electronic signatures. In Espejo versus Southern California Permanente Medical Group, the employee electronically signed various documents as part of his employment. One of those documents was a dispute resolution procedure containing an arbitration clause. When the employer sought to compel arbitration under that document, the employee objected, claiming that the employer failed to properly authenticate his signature. The court determined that the electronic signature was properly authenticated. This is because the employer was able to detail the electronic review and signature process for employee agreements. Employees often attempt to challenge electronic signatures in litigation. Employers who use electronic signatures should ensure that those electronic signatures are affixed with an employee's unique username and password, and that signatures are accompanied by an accurate date and timestamp, along with the IP address of the device used by the employee to sign the document. If an employer is unsure about its ability to authenticate an electronic signature or simply wants to avoid the argument in future litigation, it should obtain a hard copy signature from the employee. Finally, here is an update on some of the pending bills that SDSHRM has watched through the legislative process. In our last update, we discussed two bills that had the support of SDSHRM. The first is SB 985, the Workplace Flexibility Act bill that would have allowed a non-exempt employee to request a 410 schedule without daily overtime. And the second is AB 1383, which would have provided for a voluntary veteran's preference in hiring decisions. Despite widespread support, both of these bills failed to pass in committee. We will see if similar bills are proposed again next year. In our last update, we also discussed our opposition to AB 1676, which would have prohibited an employer from seeking salary history information from job applicants. Facing substantial opposition, this bill has been amended to remove the prohibition of salary discussions and will likely receive enough votes to pass in its amended form. As amended, SDSHRM no longer opposes AB 1676. Next, SB 1166 would have required small employers to provide 12 weeks of parental leave. This bill stalled in the legislature, but has now been heavily amended and has gained traction again. As amended, SB 1166 would require employers with 20 or more employees to provide 6 weeks of parental leave to bond with a new child, while maintaining employer-provided health benefits. While it is arguably well-intentioned, this bill is problematic in many respects, and we believe it requires careful consideration before moving forward. As discussed in our last update, we continue to watch SB 1063, an expansion of the Equal Pay Act to target race and ethnicity-related wage differentials, and SB 1167, an expansion of heat illness regulations to indoor employees. Governor Brown will have until September 30th to sign or veto any bills that make it to his desk. Our next video update will address the status of these and other bills of interest to employers. Your legislation committee is monitoring these and many other employment-related bills. San Diego SHRM is pleased to help keep you informed about issues that affect California employers. For more information on these and other legal topics, check out San Diego SHRM's newsletter, The Resource, at sdshrm.org. That concludes our employment law update. Thanks for tuning in.